Drone maker DJI loses lawsuit over inclusion on Pentagon's Chinese military company list. China-based drone maker DJI will remain on the Pentagon's blacklist of Chinese companies working with Beijing's military, after a D.C. federal judge dismissed its lawsuit challenging the designation on September 26. In his 49-page opinion, U.S. District Judge Paul Friedman ruled that the Pentagon's finding that DJI contributes to the Chinese defense industrial base is supported by substantial evidence, even though he cannot conclude that DJI is indirectly owned by the Chinese Communist Party. DJI acknowledges that its technology can and is used in military conflict but asserts that its policies prohibit such use, Friedman wrote. Whether or not DJI's policies prohibit military use is irrelevant. That does not change the fact that DJI's technology has both substantial theoretical and actual military application. In other words, Friedman concluded that the Pentagon had presented enough evidence to call DJI a military-civil fusion contributor to China's defense industrial base. DJI, a private company headquartered in the southern Chinese city of Shenzhen, sells more than half of all commercial drones in the United States. In October 2024, it filed a lawsuit against the Pentagon after the latter placed the Chinese drone maker and many other Chinese companies on its list of Chinese military companies operating in the United States, under Section 1260H of the 2021 National Defense Authorization Act. In a complaint, DJI called the Pentagon's decision unlawful and misguided, and said that it is neither owned nor controlled by the Chinese military. Friedman explained that companies on the Pentagon list are barred from accessing certain U.S. grants, contracts, loans, and other programs. One of the deciding factors in the ruling was the recognition by the Chinese regime's top economic planner, the National Development and Reform Commission, of DJI as a national enterprise technology center. According to the judge's opinion, Chinese companies with the NDRC's designation would benefit from free cash subsidies, special financial support from China's Ministry of Science and Technology, and a large number of tax benefits. Friedman dismissed DJI's argument that the Pentagon had not provided substantial evidence that it was currently receiving assistance in connection with its NETC designation. In light of DJI's substantial history of receiving these other forms of assistance from various Chinese governmental entities, it is reasonable to infer that DJI is also receiving assistance through the NETC program, Friedman wrote. The fact that NETC recognition is orchestrated by the NDRC, an institution that has a close connection to Chinese military planning, is sufficient for purposes of Section 1260H. The judge rejected some of the Pentagon's other justifications for putting DJI on the list. For instance, the Pentagon could only show that a Chinese state-owned company called Qingtong has some unspecified ownership stake in DJI, Friedman wrote, but it would need to provide more evidence to prove that this ownership meant that the Chinese Communist Party indirectly owns the Chinese drone maker. In an April court filing, the Justice Department told Friedman that the United States has long expressed significant concerns about the national security threat posed by the relationship between Chinese technology companies and the Chinese state. In a statement issued on Friday, DJI said it was disappointed by the judge's ruling and was evaluating its legal options. This decision was based on a single rationale that applies to many companies that have never been listed, DJI said. China-based LiDAR maker Hesai Group also filed a lawsuit against the Pentagon in May 2024 over its inclusion on its list. In July, Friedman ruled in favor of the U.S. government, but Hesai has since appealed the decision. Reuters contributed to this report.